Total is $30,517 since she has delayed this process with frivolous claims. He's lying to either this court or the bankruptcy court.
All right, counsel, let's hear this case. Put the position one, Miss Williams, on mute. Come to a place where you can stop and not walk around. I need you to unmute. I know you got the baby in your hand, but I need you to unmute.
I do. I'm sorry.
It looks like you work at a daycare. It looks like you work at a daycare right now.
I got a sick grandbaby.
No, well, see, that's like a daycare in and of itself. You got a big grandbaby. Like
so, can I say something?
Not yet. Let me get you under oath. Raise your right hand.
Oh, Lord, wait. Okay, here we go.
Okay, well, you got a baby in your hand. It's okay. You swear or affirm to tell the truth under penalty and perjury of the law?
I do.
Okay. All right, I'm going to ask the counsel, some attorneys, some questions first, and then I'm going to come to you and get exactly what's going on with you. Just hold tight. So,
okay.
Counsel.
Can I mute again?
Yes.
I'm sorry. I got babies everywhere.
I got it.
Your Honor, I'm asking that the default that was issued on June 16th in front of Judge Egerton be held up and not be vacated. There's nothing that's filed to indicate it should be vacated. Ms. Weems is not on the lease. This case has been going on for over a year. We have been to court 6 different times. When Ms. Weems ran out of other options, she decided to file a notice of bankruptcy, which had already been filed, but it wasn't until 6 months afterwards that she decided to file and try to include this in the bankruptcy. We got a motion to lift the stay. We had a writ in November of last year because funds were not paid into the rent into the registry pursuant to an order dated September 2024, signed by Judge Grant.
Mm-hmm.
There is absolutely no reason that the default should be vacated. Ms. Weems didn't file anything. Ms. Weems isn't on the lease. She's the mother of Mr. Williams. And so we are asking for the default that was sent to Mr. Egerton, or that was issued, although not signed, it was sent to Clerk Lane on June 16th, be upheld.
Okay, and that, give me 1 second. I was looking here and I saw the proposed order. Bear with me. And that was from a June 16th hearing, is that correct?
Yes, Your Honor.
Okay, bear with me. Okay, and did I see this is money against Mr. Williams? Let me just make sure he was the one just confirming that he answered all. All right, well, part of the issue, no, wait. Yeah. Part of the issue, I just want to just see from the beginning, is that I don't believe Mr. Williams ever answered. I have to just check on service if he got personal service. But if he got personal service, no second mail, then the order that's currently, it's not signed, but as far as the money judgment amount against him wouldn't be applicable because he never was served, nor was he answered. It seems as if Ms. Weems filed the answer in the case.
Then I would, correct. Oh, then I would ask that the judgment be issued against Ms. Weems since she has delayed this process with frivolous claims and bankruptcies and everything else for over a year. She has inserted herself into this case, and I would ask that that the default be issued against and the judgment be issued against her. Then, from the June 16th hearing, she received notice.
I get that, and I understand the basis for that, but I do want to, if she's never lived there and never had any basis of getting any benefit, then obviously it wouldn't make sense to do so. Just because you answer and you don't receive any benefit doesn't justify having an order or judgment. It's gotta make sense. I'm here for the default. I'm here for the writ. But
yes, Your Honor.
But just let me see about the judgment amount, because if the judgment amount, I know she filed an answer, but again, filing an answer doesn't in and of itself automatically make you, subject to any money judgment. It still has to be justified, right? So
it does not, Your Honor. However, Ms. Weems filed into the case on December 27th. I'm sorry, where did she file it? She filed December 27th, 2024, a document indicating that she was living out the property in order to get relief from the bankruptcy stay. Okay. Which she got. So that, whether she is living there or not, she has proffered to this court that she is, although she has not changed her address with the bankruptcy court. So she's lying to either this court or the bankruptcy court, because obviously she cannot be living in both places at the same time.
So let me ask. I mean, listen, I've got the gist now. I know where you're going. I know what's going on. I see the money judgment amount. I'm going to at least ask her some questions, because obviously the order that is currently in there, I'm not going to sign, because it again has the wrong party. So I'm not going to do it against Mr. Williams, because again, he hasn't been served and he didn't file an answer. Whether or not I'm going to give $31,000 judgment to her is dependent upon a couple of questions that I ask. And I think that's what my job is to do. You may not like it. That's what my job is. So I
understand, Your Honor. I do.
Let me ask Miss Weems some questions. Miss Weems, unmute for me. Miss Weems.
I'm unmuted.
Yes. Couple things. Did you ever sign a lease in this case for this property, to stay at this property?
Yes, I did.
When did you sign this?
So when we moved into that place, there were 3 of us listed on there. One of them was my son's fiance, who has passed away. Myself and my son. The reason that this case was reset is and not given a default judgment on the 16th is because Judge Ed, I'm finna butcher his name, I'm sorry.
Edgerton.
He spoke to me himself along with my case manager, who informed him that she had issued a check in the amount of $26,000 and some odd dollars to Vinebrook through Miss Jennifer, and the remaining was paid into the court. So I would be paid up until July, and we are actually moving at the end of July. So that's why it was reset, because...
Well, hold on. I hear what you're saying. So let me just get a couple of things out from you. You've always lived at this property? Is that the case? Do you currently live there now? Is this your current place of residence?
Absolutely, yes.
Okay, so if you had any other ID and statement of otherwise, that would be untrue.
What do
you don't live nowhere else? This is your dominant.
No, I don't live. This is where I've been. This is where all my mail comes. The bills that are in my name, I have that as well.
Okay. When's the last time did you personally pay any money on it regarding rent?
When I paid the money into the court registry.
Okay, you paid the money into the court registry. All right.
Yes.
And this $26,000 that you're referring to, where did this money come from?
It came from the Jewish. Let me go get the paper, because there's a letter. There are 2 letters filed in the case that the judge saw that tells you it came from the Jewish Community Center. And my case manager is Journey Alexander. And like I said, she was with me.
Let me ask you this question.
Yes.
I don't see no check from nobody to nobody. I see a letter. A letter. Right. So I see a letter dated June 2nd. And who is supposed to get this check?
Vinebrook.
Okay.
The check was made out to Vinebrook, and that was the purpose of having the case manager.
Are you aware of whether or not Vinebrook got this money?
Yes. Jennifer got it. I don't know who Jennifer is, because I never know who nobody is, because they changed so much.
Okay, hold on. All right, counsel.
Your Honor, I have a witness here from Vinebrook will testify. They don't have any funds, and even if they had received funds, it would have been returned. But I have Ms. Ferris here to testify. They are not accepting rental assistance. This was the same claim that Ms. Weems made almost 8 months ago, 7 months ago. We want judgment in possession. Funds are not an option at this point, but I have Ms. Ferris here that can testify that no funds have been received.
Okay, I'm going to get Ms. Ferris under oath. Ms. Ferris, unmute for me.
Hello.
Can you raise your right hand for me? All right, Ms. Ferris, you swear or affirm to tell the truth under penalty and perjury of the law?
Yes.
All right. So I'm going to ask you counsel, you want to ask her the questions? That's fine.
Ms. Ferris, have you received any funds from rental assistance on behalf of Ms. Weems or Mr. Williams?
No.
Have you received any funds from Mr. Williams or Miss Weems since this case was filed in June of 2024? I'm sorry. I didn't hear it.
No.
You have possession of the property?
No.
All right. And Ms. Williams, did you have any questions for Ms. Ferris?
I do.
Okay.
Ms. Ferris,
Yes.
is she there? Back in January, it may have been February, when we spoke in the courthouse, and I told you that they were going to be contacting you to get those funds to you. Do you recall that?
I recall that conversation, but we've never received funds from them.
So do you have anybody working for you, Jennifer?
I do not know, not under my team. I'm not sure if there's someone in a different department, but as the attorney said, we haven't received anything, and the funds would have been sent back at this point had it been sent to our office.
So the funds were sent to Jennifer because that's the person that they've been able to contact because they couldn't get you.
Well, Ms. Williams, now you testify for the lady. Just do you have any other questions? I'm just trying to give you an opportunity to ask, to make sure that I try to be reasonable here. Is there anything specific that you're trying to point out? Let me ask you this. Do you have any proof that someone has cashed a check?
No, but the lady who is not available now, but that was in court with me on the 16th, is the case manager who had that information. So
this is the issue, right? The issue is that you're saying that his payment has been submitted. They're saying that even if they had payment, they would have returned it, and there's no confirmation that the payment has been accepted. If that was the case, then we could stop this case right now because payment would have been the moment they cash any check and have it returned it to you by the time we have a hearing, case done. But in the event that that's not the case, then ultimately they're not required to take that money, right? And so you're ultimately still in a situation of default. We don't have any other basis. Now, obviously, the default that you had previously from the 16th, I am not going to approve that because obviously the order that happened wasn't okay. But I'm going to make an order based on today's findings. And I think that makes more sense. And I know that Attorney Cruikshank, that'll make you upset because I am going to give her an opportunity to appeal, but there is going to be a money judgment that I'm going to find against Ms. Weems since she indicated that she's the person who not only was occupying the property, had paid the rent, and ultimately paid rent into the registry. Right. So just want to make sure that's clear.
Fine,
Now,
I understand.
Ms. Weems, if there is something that happens in between time, and I always tell people this, if somehow the court always wants to get it right. If there's some type of evidence otherwise that indicated that this money had been accepted and tendered, and this people just don't know about it, feel free to take a look. But based upon the evidence that I have in your testimony, I don't have any evidence to support the fact that the money had been accepted.
So the case manager for the Jewish people who is on vacation now, who has a direct number, if she's is saying they've been cashed, what do I have to do to show that they've gotten the money?
We need to show that the check had been deposited or some type of other source, or maybe they can tell you that from their bank account that it's been deposited or was deposited. But I mean, without any other information to support that, it's just another allegation that money would be paid, but it hasn't been. And they're confirming that even if it was sent, they wouldn't have accepted it. So I have to accept that unless you had evidence otherwise.
And I hear what you're saying, but the Miss Ferris, who I had been dealing with, says that she doesn't know the Jennifer person. She may be in another department.
I understand, but they're also here representing these people as attorneys, and that's what we're here, and it's not their burden to prove your case. And I'm not trying to be rude, but that's
no. I get what you're saying. I understand what you're saying.
So this is what I'm going to do. I'm going to identify counsel. What are you saying the judgment amount is through July 8th?
Through July 8th, Your Honor, the judgment amount is $33,056.21. That consists at the time of filing $4,710 in back due rent for May and June, one late fee of $50, utilities of $176.88, along with 12 months at $2,300, which is what Judge Grant found the monthly rent was in the September. I also have a witness that can testify, plus 8 days of, well, I only did 7 days, but that's fine. 7 days of July.
Well,
No other additional late fees or attorney fees.
Because it's a day.
That's incorrect.
Okay, and why is that incorrect, ma'am?
That's incorrect because for May and June, we took care of that in the court with Mr. Luke. That is in the documentation. So it would have gone from July to July.
Okay. Well, so let me just clarify, because I do want to get the amount right, counsel. I do see that she paid into the registry one time in September, but that was $1,200.
And that's because
we can give a credit for that, Your Honor.
Okay, I just want to make sure. Listen, I'm making sure I do it right. You understand?
So the reason that it was the $1,200 and not the $2,300 is because Mr. Luke gave me credit for May, because I had documentation showing that May was taken out of my account, and for June I had to pay $1,100 for a $4,000 water bill. So Mr. Luke gave me credit for both of those months, which is why I only had to pay $1,200 instead of $2,300, which is what the rent was.
Now, but now let me just be clear, ma'am. The order for you to pay into the registry was ultimately, let's see here. Well, yeah, I'm sorry. So counsel, she has $1,200 due on September. So that's how much they wanted her to do in September. And then there was going to be $4,698. And so they indicated through October 2024, the amount would be, this is really strange. It's almost like a consent order. It doesn't make any sense. The total amount that you were supposed to pay was $10,498. And then out of that $10,498, that would have been through October, apparently. That would have been, you paid $1,200 of that. And then, so that would have ultimately left you with about $9,298 that you would have had to pay through October. And then you would have had an additional now 9 months and 8 days. So $9,200 plus 9 months and 8 days, counsel.
I'm doing the math, Your Honor.
Thank you. Thank you for everyone else's patience.
The total is $30,517.40.
30,005 what?
$517.40. The balance from the $10,498.07 is $9,298.07. The rent from November through June is $20,700, and then 7 days of July, $519.33.
Okay. All right. Bear with me. So that's going to be the money judgment amount. Ms. Williams, I'm required to tell you that there will be 7 days from the date that you would have to appeal. You can't appeal any time after that. But there will be required that you pay into the registry $30,517.40 if the event that you were to exercise that right to file an appeal.
Okay.
Yeah, no worries. And then the money, the writ of possession will be available on July 8th, 2025 at 11:59 p.m. All right?
Okay.
Your Honor, for the appeal provision, just so it's clear, the remaining amount for this month would also be $1,780.67, and then the $2,300 would begin August 5th.
Yep.
So she would actually need to pay, if she was going to appeal, the appeal
The $2,300
provision
for July, correct?
would be $34,836.88.
Okay, well, we'll if that's what she's going to do, obviously we'll see. But that's the order of the court. Ms. Williams, did you have anything else?
I still don't think those numbers are correct, but I'm just
basing it off the last order from the judge, ma'am, and then the remaining rent that it would have been paid since then, since there's nothing else going on. Okay, so I appreciate you. I will get an emailed order over to you. And so your motion ultimately was granted, but obviously we had a hearing now, and so this will be the order of the court. All right?
Okay, that's not a problem. So I do have one question though.
Last question. Move along.
Last question. I promise it's the last question. If the my case manager if I can bring a copy of the front and back of the check showing it was cashed by them on Monday when she's back in the office.
You need to just submit that to the court. I won't tell you what I'm going to do until I see what you're going to submit.
I got you. I appreciate it.
Yes, ma'am. All right. You're free to go. Thank you, Kirk. I'll get the
Thank
order
you.
in. Don't have to worry about it. I'm drafting it myself.
All right.
Thank you, Your Honor.
Thank you. You're free to go. All right, folks. I know you're impatient. Impatient.
With another party such as this, and you just can't seem to work it out. Don't resort to taking the law in your own hands.
We'll hear the litigants' reaction after these messages.
All right, thank you very much. Officer Bell's waiting for you, and that will bring this case to a conclusion.